In 1946, the General Assembly of the United Nations recommended that members of the United Nations should take necessary legislative or other appropriate measures to prevent the use without proper authority and in particular for commercial purposes of the emblem, the official seal and the name of the United Nations and of the abbreviations of that name. Instances also come to light of the use of India, of the Indian national flag and emblem and the names or pictorial representation of Mahatma Gandhi and other national leaders for commercial and trade purposes and in a manner likely to offend the sentiments of the people. For commercial and trade purposes and in a manner likely to offend the sentiments of the people. Accordingly, to prevent the improper use of certain emblems and names for professional and commercial purposes, the Emblems and Names Prevention of Improper Use Act 1950 was notified in the Gazette of India on 1st of September 1950. The Emblems and Names Prevention of Improper Use Act 1950 was notified in the Gazette of India on 1st of September 1950.
As we Indians celebrate our journey of 75 years of independence, Sansad TV pays tribute to the said phenomenal journey by dedicating a series titled 75 Years Laws That Shaped India. A special program conversing different laws that have been adopted during these golden 75 years. I'm your host, Hemant Batra, back with another episode in that exclusive series. Today we are discussing the Emblems and Names Prevention of Improper Use Act 1950. To talk about this significant legislation, we have with us a very learned and proficient panel. We are joined by Parag Tripathi, a very distinguished and eminent senior advocate at the Supreme Court of India, and also a former Additional Solicitor General of India. Welcome, Parag. We are also joined by Rekha Agarwal, a highly accomplished senior lawyer at the Supreme Court of India. Welcome, Rekha.
Thanks, Hemant.
So let us start with our discussion. Let me come to you first, Parag. Parag, we are discussing this act which is about prevention of improper use of emblems and names for professional and commercial purposes. Can you please tell our viewers what constitutes an emblem? And if you could also give us some instances and specifics about some of those emblems which are protected under this act.
Yeah, Hemant, this is a very necessary and important act. और अधिकांश लोगों को इस एक्ट के बारे में ज्ञान नहीं है. और इस एक्ट का पर्पस ये है कि जो नेशनल एम्ब्लेम और नेम्स हैं उनका इम्प्रॉपर यूज़ बाधित हो. तो इम्प्रॉपर यूज़ होता है प्रोफेशनल और कमर्शियल पर्पसेस में. जैसे एक जजमेंट है सुप्रीम कोर्ट का जहाँ ये शेड्यूल में उन्होंने लिखा हुआ है कि क्या क्या नाम हैं और क्या क्या एम्ब्लेम्स हैं जो आप यूज़ नहीं कर सकते हैं विदाउट परमिशन ऑफ द सेंट्रल गवर्नमेंट विच हैज़ कॉन्स्टिट्यूटेड अ कमिटी. तो जैसे एक रजिस्टर्ड ट्रेडमार्क था छत्रपति शिवाजी बीड़ी. तो जब ये एक्ट आया तो उसके बाद रजिस्ट्रार ने कहा कि आपका नाम हम हटा देंगे जो आपका ट्रेडमार्क है. तो वो सुप्रीम कोर्ट तक गई बात. तो सुप्रीम कोर्ट ने कहा कि ये बिल्कुल सही है क्योंकि वैलिडिटी को चैलेंज किया गया. तो जो शेड्यूल है उसमें बहुत सारे इस तरह के एम्ब्लेम्स हैं जो हमारे राष्ट्र को के गौरव से इंटरकनेक्टेड है. अच्छा. वो हमारी राष्ट्रीयता के एक तरह से प्रतीक है. जैसे राष्ट्रपति भवन, जैसे हमारे अशोक चक्र, धर्म चक्र, शारदा मठ, इस तरह कृष्ण मठ. तो ये जो हमारे कल्चर से और देश से जिनमें हमारे देश का एक तरह से गौरव निहित है वो सारे के सारे हमारे शेड्यूल में हैं. और उस शेड्यूल में जो एम्ब्लेम्स हैं उनको अगर आप यूज़ करेंगे विदाउट परमिशन तो वो सेक्शन 3 में एक वायलेशन ऑफ द एक्ट हो जाता है। तो एम्बलम का डेफिनेशन है सेक्शन 2 में कि एनी एम्बलम, सील, फ्लैग, इंसिग्निया, कोट ऑफ आर्म्स, पिक्टोरियल रिप्रेजेंटेशन स्पेसिफाइड इन द शेड्यूल। तो ब्रॉड डेफिनेशन है, क्योंकि राजस्थान हाईकोर्ट ने कहा था कि कॉन्स्टिट्यूशन और हमारा जो एम्बलम्स हैं वो राष्ट्र के गौरव का प्रतीक है, और वही सुप्रीम कोर्ट तक वो अपहोल्ड हुआ है। तो इट इज प्रोटेक्टिंग द हेरिटेज एंड द कॉन्सेप्ट ऑफ इंडिया।
ठीक है,
ये इंपॉर्टेंट बात है।
तो इसके फॉलोअप में जो एक क्वेश्चन मेरे जहन में आ रहा है वो ये है अबाउट यूसेज ऑफ एम्बलम्स बाय प्राइवेट इंडिविजुअल्स, बाय कॉर्पोरेट एंटिटीज, बाय फर्म्स एंड इवन पब्लिक ऑफिशियल्स फॉर दैट मैटर। कौन कौन सी प्रोहिबिशंस हैं यूसेज के बारे में एम्बलम्स की?
नहीं, ये बहुत आपका इंपॉर्टेंट प्रश्न है, क्योंकि सेक्शन 3 और 4, क्योंकि ये बहुत ही छोटा एक्ट है। अगर आप इसको कंपेयर करें इनकम टैक्स एक्ट से, जो ABCD BBCD चलता चला जाता है, आदमी भूल जाता है कौन से सेक्शन में है। इसके सारे कुल मिला के 9 सेक्शन है, 3 पन्ने का एक्ट है और 2 पन्ने का शेड्यूल है। तो प्रोहिबिशन जो है वो इम्प्रॉपर यूज ऑफ एम्बलम्स एंड नेम सेक्शन 3 में है, जो ये बाधित करता है कि आप एम्बलम का यूज, कंटिन्यूएशन ऑफ यूज नहीं कर सकते, बेसिकली प्रोफेशनल और कमर्शियल पर्पसेस के लिए। कि जैसे आप मान लीजिए कोई फुटवेयर बना रहे हैं, उसमें आपने नेशनल एम्बलम लगा दिया, तो ये नहीं कर सकते आप। चाहे आप कार बना रहे हैं, उसमें भी आप नेशनल एम्बलम नहीं लगा सकते। सवाल ये नहीं है कि वो कहाँ प्लेस होती है चीज़, सवाल ये है कि ये चीज़ कमर्शियली एक्सप्लॉइट नहीं की जा सकती, प्रोफेशनली एक्सप्लॉइट नहीं की जा सकती। इट नीड्स प्रोटेक्शन।
तो अंडरलाइंग फीचर बेसिकली ये है कि आप यूज करिए, लेकिन उसका कोई कमर्शियल आउटपुट नहीं होना चाहिए।
परहैप्स अगर आप एग्री करें मुझसे, तो अंडरलाइंग कॉन्सेप्ट ये है कि उसको आप रिकॉग्नाइज और रिस्पेक्ट करिए, यूज ना करिए।
अच्छा, यूज
ना करिए, क्योंकि एम्बलम इज समथिंग विच स्टैंड्स एट अ डिफरेंट फुटिंग। तो उसको आप रिकॉग्नाइज करिए, उसको रिस्पेक्ट करिए, उस गौरवान्वित फील करिए उसको देख के।
बहुत सिग्निफिकेंट बात की है आपने, जो वैसे इस एक्ट में ये निकल के नहीं आ रही है, लेकिन अंडरलाइंग ऑब्जेक्टिव लगता यही है, जो जैसे आपने अभी बोला।
जी
बिल्कुल। रेखा, जैसे अभी पराग ने बोला कि कैसी जो कुछ प्रोविजंस हैं जो जिसका इम्प्रॉपर यूज नहीं हो सकता, चाहे कमर्शियल है चाहे वो प्रोफेशनल है, और इट इज बेसिकली अ मार्क ऑफ रिस्पेक्ट, यू नो, विच हैज टू बी ऑनर्ड। जरूर इसमें कोई ऐसा मैकेनिज्म भी होगा कि अगर कोई इम्प्रॉपर यूज करता है, या लेट्स से, in other words, if I was to put it, if somebody violates the provisions of this act, so what consequences will they be meted out with?
See, हेमंत, पहले तो इसके बारे में कोई कानून था नहीं, स्पेसिफिकली नहीं था। अगर हम तिरंगे झंडे की भी बात करें साथ साथ, जैसे अभी बात हमने करी है कि एम्बलम्स के बारे में, तो जब हम नेशनल एम्बलम्स की बात करते हैं और साथ साथ अगर हम अपने नेशनल फ्लैग की बात करते हैं या अपने नेशनल एंथम की भी बात करते हैं, तो ये वो सब चीज़ें हैं जिनके बारे में हमें एक भारतवासी होने के नाते वी शुड बी वेरी प्राउड ऑफ इट, एंड एक पेट्रियाटिक फीलिंग अपने मन के अंदर आनी चाहिए। तो पहले तो सिर्फ एक पंजाब के अंदर एक कोड था इसके बारे में, और बाद में 2002 के अंदर एक फ्लैग कोड हमारे देश के अंदर भी बना, और उसके बाद में ये क्लियर हो गया कि अगर कोई भी व्यक्ति इन चीज़ों को मिसयूज़ करता है या उनकी जो छवि है उसको धूमिल करने की कोशिश करता है, उसका कोई कमर्शियल यूज़ करता है, सो देर इज़, कई बार ये हो सकता है हेमंत दैट नो दे मे नॉट बी अ विलफुल वायलेशन, किसी को पता भी नहीं है कि मैं काम जो कर रहा हूँ मैं गलत कर रहा हूँ, और वो होता है कि इनएडवर्टेंटली, अनायास किसी ने कुछ गलत काम कर दिया है, मिसयूज़ कर दिया। बट उसके बाद के अंदर जो हमारा 2005 के अंदर जो कानून बना है, उसके तहत अगर कोई भी जानबूझ के अगर उन चीज़ों को, हमारे नेशनल एम्बलम्स हैं या नेशनल फ्लैग है या नेशनल एंथम है, उनकी किसी भी तरीके से उसकी जो इमेज है उसको खराब करने की कोशिश करता है, डिसरिस्पेक्ट द नेशनल फ्लैग और द नेशनल एम्बलम्स।
What are the penalties which are provided under the act with regard to violation of any of the provisions of the statute?
As I just said that, you know, since most of these actions are done inadvertently without any object behind it to disrespect or the national emblems that we are talking about, so the punishment is that the 500 rupees fine can be imposed upon the offender. But of course, for imposing that fine, also the prosecution, the permission from the state agencies has to be taken before the prosecution can be launched against the offender.
Well, it is time to slip into a very short break. We'll be back soon. Welcome back after the break. You're watching our special show on selective landmark laws legislated during our journey of 75 years of independence. Today we are discussing a significant law, the Emblems and Names Prevention of Improper Use Act 1950. There have been some landmark judgments in respect of this act, and we will want our viewers to learn about the same, but only after glancing through the parliament journey of this act.
The Emblems and Names Prevention of Improper Use Act 1950 was passed by the Provincial Parliament on 13th of February 1950. The Minister of Commerce, Dr. K.C. Neogi, moved the bill to be passed on 13th Feb 1950. The bill then received the assent of the President of India on 1st of March 1950 and came into effect on 1st of September 1950. The Act extends to the whole of India and also applies to citizens of India outside India. Let us view and hear some of the significant debates in the Parliament on the said Act.
I wanted to submit that big merchants are earning millions of rupees by utilizing names of our leaders. A mere of rupees 200 or rupees 500 would be of no avail.
The bill would relate to the names, emblems or official seals of the United Nations Organization and also of the World Health Organization. The Indian national flag and the official seal or the emblem of the central government or any of the state governments or any department of any state government.
So returning to our discussion, Parag, if I remember it correctly, until 2004, there were massive restrictions, stringent restrictions with regard to usage, installation, display, and flying of Indian national flag.
Yes.
And then came the highly reformative judgment of the Supreme Court in Naveen Jindal's case. Can you tell our viewers about the gist of this judgment and even the backdrop of why this case was brought about?
Hemant, one thing I must clarify before we move on to the Naveen Jindal judgment. There are actually 4 provisions of law which deal broadly with this aspect. One is, of course, the Emblems and Names Prevention of Improper Use Act 1950, which we are discussing today principally. There is also the 2005 State Emblems Act. There is also a 1971 Prevention of Insult to National Honours Act. And lastly, there is in Fundamental Duties chapter in 51 capital A, small a, deals with the respect to the national flag, etc. So it's an area which is well covered. And one more thing we should remember, that 26 January 1950 is when we gave ourselves the Constitution, and this act came almost right on the heels of the Constitution itself. So it's a very important act as far as the polity and the social fabric of this country is concerned. Now, coming to the question which you asked me about the Naveen Jindal case, this was actually a PIL of sorts filed by an industrialist, then industrialist, later on he became an MP and an educationalist as well, Mr. Jindal, where what was challenged was the flag code of 2002.
I see.
So Supreme Court said 3 things. The right to fly a flag is a part of freedom of speech and expression.
Right.
That is 19(1)(a).
So it's a fundamental right.
It's a fundamental right. It has also the trappings and the essence of another fundamental right, that is Article 21. So it's a part of your human dignity. And since it's a fundamental right, the restriction has to be, and since it's 19(1)(a), restriction has to be in the form of a law under 19(2). The restriction can't be by an executive code. So by an executive code, by an executive action, you cannot restrict fundamental rights.
Right.
So these are the three things, and of course it said that you can fly the flag, but it has to be done reasonably, with due respect, etc. All those things are there, but you can't by a code say that you cannot fly the flag, because if you see in most countries of the world, particularly US, the flags are flown everywhere. In Europe, whenever you have football matches, you will find fans standing on top of their cars and waving the flag. So flag is a part of your national conscience, it's a part of your national identity. So this was decided by a division bench judgment of the Delhi High Court, and then it came up to the Supreme Court before the bench of the then Chief Justice, Justice Khare, and it is his judgment which laid down these propositions. So then you were entitled to fly your flags, and look how nice it has been, because recently government also said that there should be har ghar mein ek jhanda ya har ghar mein ek tiranga, because it's a part of your conscience, and it is a great uniting factor.
Absolutely.
So therefore I think this judgment was a great blow for freedom of speech and expression and the rights of citizens in this country.
Very well explained, Parag. Rekha, are there any other legal, judicial precedents?
Yes, in the past there have been many cases, where the freedom of speech and expression, the right to the responsibility that every citizen has to honor the national flag and the national anthem, etc., have been discussed by the High Courts as well as the Honorable Supreme Court. And in all these judgments, what has been basically discussed is what is the mens rea, what is the intention of the person who is in the docks for allegedly violating the national anthem or the national flag, or disrespecting the national emblems. So one of the cases which I would like to discuss over here is about the case in which there was the emblem of Chhatrapati Shivaji, which was being used on a beedi, and where the court said no, you cannot use the photo of Chhatrapati Shivaji because there's a certain emotional national feeling attached to it. That was the case of Sable Bagayer and Company versus Union of India, where they had challenged, because earlier they had been given the right to use that particular photo as a part of their trademark. And then the Supreme Court said law is never static. And even though earlier when this trademark was granted to them, at that time they were granted the right to use the photo of Chhatrapati Shivaji, but later on, it cannot be an exhaustive list. So later on it was added. So this company, this beedi making company, was denied the right to use the figure of Chhatrapati Shivaji. Then there has been another case recently which I will discuss. That is the case of Vcon Media and Broadcasting. In this case, the name of the channel was earlier Harvest TV. And later they wanted to change it to Tiranga. So the Ministry of Information and Broadcasting did not initially permit them to use this name on the ground that no, you are going to make a commercial profit out of it. And by using the name Tiranga, you are sending a wrong message and you're going to make a commercial use of it, so it cannot be allowed. But ultimately, the company had its way, because simply using the three colors, that is saffron and white color and the green color, that ipso facto does not imply that you are disrespecting the flag or that you're making a commercial use of it. Right. So using those three colors of the Tiranga flag will not constitute a violation of the act. Then there have been other cases, there is this case in which in Gujarat there was this company, which was selling salt, the table salt that we use, namak. Right. And they were using the figure of Mahatma Gandhi, the father of the nation, and that too along with the photo portraying the Dandi March. So here was somebody selling for commercial use namak, and you had the photo of the father of the nation along with it, Dandi, of the Dandi March particularly, giving the impression to the public, who are going to buy it, that somehow this has got an endorsement by Mahatma Gandhi. And the courts came down heavily. There was
and Mahatma
prosecution.
Gandhi, that name, sorry to interject, the name Mahatma Gandhi and the pictorial representation constitutes part of the schedule.
It does. It does.
Of
Yes.
this
Yes.
act.
It does. It is part of the schedule, which is, I will say, a protected name and emblem.
Yeah.
So the Andhra Pradesh High Court in this case, prosecution permission was sought to prosecute the company, and they said it's absolutely right. You cannot be permitted to use the name or the figure of Gandhiji, and that to the Dandi March, because as it is, and the court was of the opinion that here was a man who gave up his life for getting the freedom of our country, and obviously there's been a lot of exploitation of the name, and the due respect which the father of the nation ought to have been given in his, has not been given. So the courts did not permit him to, permit this company to use the figure of Dandi March in the salt. So the basic concept is that though there is a freedom of speech and expression under Article 19 of the Constitution, but no fundamental right is absolute. There are always checks and balances to it.
Absolutely.
So if you are, while you exercising your right of freedom of speech and expression, you must also remember Article 51, which enshrines upon you the duty to respect the nation and its emblems and anthem. So that dichotomy should not be there. There has to be a balance in that. And in due course, people should learn to respect, exercise your right to freedom of speech and expression, but at the same time, do not show any disrespect. That is the underlying theme of all these judgments. And we have to see that what is the intention of the people who are alleged to have been offending.
Yes. Very useful information shared by you, Rekha. Let us move on to the viewer's question. We have a question this time from Rakshit Taneja from Chandigarh. Let us listen in.
The schedule of the Emblems Act 1950 includes names and emblems belonging to global, national, development, charitable, spiritual, and even somewhat religious institutions. Do you think the inclusion of all these names is within the objective of this act?
Parag, would you like to take this question?
Yeah, I think that's a very, very good question, Hemant. The question is, are we going overbroad in our schedule for giving the protection? And by becoming overbroad, as you know, it's a part of Article 14 that equal should be treated equally. So if you are treating unequals equally and going overbroad, you are again doing disservice to the act. I think for some of the additions, that question is I think it requires consideration. And there is actually a provision in the rules for a committee which will decide additions to the schedule and deletions from the schedule. And I think time has come for that to be examined. Because some of the entries which, as he rightly says, do look to be a little beyond. And if you increase the number of entries, you comparatively dilute the importance of the principal purpose of this act of national emblem, like for instance the flag.
So, I might just add to what Parag said, that there are certain emblems where there is a kind of a grey area. So while protecting the national emblems of a country, there should not be an overkill. So the very purpose of the act is going to be defeated if we are going to be overtly sensitive and add so many names in it which may be sort of crossing the line. So it has to be very, very choosy, it has to be selective, but of course it cannot be static. Names have to be included, but not so many names can be included that the freedom of speech and expression also goes away.
Absolutely.
Hemant, there was a very nice one-sentence pithy saying from an American Supreme Court judgment. Talking of the national flag, he said, if the national flag says anything at all, it says everything.
Yes.
And that actually sums it up.
That sums it up. Well, the objective of the legislature, while making this law for preventing the misuse of national emblem, state symbols, etc., was profusely clear, as it wanted people not to get tricked by such violators who would use these symbols and emblems deceptively or without approval to make undue gains. Thank you so much, Parag Tripathi, Rekha Agarwal, for sharing your expert views. Well, the discussion today was truly, truly enlightening. That's all we have in this edition of the program. Thank you for watching. Goodbye and namaskar.